For many people, they believe the only way to beat a criminal case is to have a trial and have a jury or a judge decide that you are not guilty. However, sometimes a criminal case can be beat at a much earlier stage in the process. In every state in the United States, there is an early hearing that gives you an opportunity to beat a criminal case. In Pennsylvania, it's called a preliminary hearing. And today, I am going to go through with you 3 ways to beat a case at the preliminary hearing. However, before I get started, if you like my content, please subscribe, like, comment, and share. Subscribing to my channel helps me to get more viewers, to show YouTube that I have viewers, and therefore YouTube will show my videos to even more people. The more people who see my videos, the more I know that my content is having an impact. I will be incentivized to make more and more videos and produce more and more content. So it's something easy that you can do to help me out, to keep me going. So please subscribe, like, comment, and share. Now, let's talk about 3 ways to beat a case at the preliminary hearing. Number 1, you can beat a case at the preliminary hearing if the Commonwealth or the state can produce no witnesses. The preliminary hearing, I like to describe it as a gatekeeper stage. This is an early stage of a criminal case where it goes before a small court's judge. That judge will hear and see if the Commonwealth has just enough evidence to show that a crime has been committed. They don't have to prove their case beyond a reasonable doubt here. They just have to put some small amount of evidence on the record that a crime was committed. But sometimes the Commonwealth's entire case can rely on witnesses who are not police officers. When that is the case, those witnesses, even if they've been subpoenaed by the police for one reason or another, may not show up to the preliminary hearing. They may be in the hospital, something bad may have happened to them, or perhaps they just defy the subpoena. There's a whole range of reasons why those witnesses would not show up. And it just may be the case that the only evidence the state has against a criminal defendant comes from 1 or 2 witnesses who are not police officers. This doesn't happen often, but it does happen where these civilian witnesses do not show up to talk about what they saw or what the crime was. If that is the case, the Commonwealth may not even be able to show that tiny bit of evidence that they need to hold the case over. So that is one scenario where you can beat a case at this early preliminary hearing when the Commonwealth has no witnesses. Number 2, hearsay. Sometimes the Commonwealth's entire case relies on hearsay. Even, let's talk about scenario number 1 where they have no witnesses. Well, the Commonwealth may decide to try to have the police just read the report to the judge in order to have the case held over. However, if that entire report is based on statements that were made by another individual, that is hearsay. Hearsay is technically an out-of-court statement used for the truth of the matter asserted. If the Commonwealth attempts to prove their case purely by hearsay, you can object to the hearsay being admitted, and then you can argue at the end that the hearsay itself is not enough to show that that a crime has been committed, even if it is just a tiny bit of evidence. Now, the law will be different on this state to state. Some states may allow hearsay and some states may not. However, you want to object to it in every scenario, and sometimes a magistrate, a smaller court judge, if they think the case is relied upon entirely by hearsay, will throw the case out. The third way you can beat a case at a preliminary hearing is by making a legal argument. Let's assume that the prosecution, the Commonwealth, has brought their witnesses to the hearing and that these witnesses are going to testify on personal knowledge, on something that they saw. Therefore, they won't be relying on hearsay. The prosecution has brought their witnesses and they're not relying on hearsay. Thus, they are going to testify on the record that the defendant committed some sort of criminal behavior. In this situation, you're going to have to make a legal argument to beat the case because, like I said earlier, credibility is not at issue at a preliminary hearing. Now, let's use an example. Let's say that the defendant is charged with stalking. In order for a defendant to be convicted of stalking or for the case to go beyond the preliminary hearing level, the Commonwealth needs to show that the individual was continuously and repeatedly following someone in a threatening or intimidating behavior. Now, here's a pattern of facts that may occur in which you can make a strong legal argument. Let's say the alleged victim, the witness here, lived in one house and the defendant who's charged with stalking lived in the house right next door. And the witness testifies that the defendant was following this person because he saw her every single day outside of her house. However, again, like I said, this individual was just going back to her house. Now, her perception of him following her was likely just him going back to his house. Those facts may be crucial to showing a continuous and repeated effort to follow her. At the end of that hearing, you can make an argument to the judge that those facts are not enough to fulfill the element of stalking that requires repeated and continuous following, because this individual was going to his house. He was not going to her house, and there was no intent there for him to stalk her. This is a scenario that I've actually seen played out in court, and I've actually seen a judge dismiss a case on these facts and on that legal argument. So once in a while, you can make a legal argument if you know the elements of the crime and tell the court that the facts don't fit the elements, therefore the case should not be held over even at the preliminary hearing level. So let's run through one more time the 3 ways to beat a case at the preliminary hearing level. Number 1, no witnesses. When the Commonwealth can't bring their witnesses, oftentimes these are non-police witnesses. If they don't show up, they may not have a case at all. Therefore, you can beat it when there are no witnesses. Number 2, hearsay. If the Commonwealth or the prosecution's entire case relies on hearsay, you may be able to argue to the judge and object to the admission of hearsay and beat it even at the preliminary hearing. Number 3, there may be a legal argument that you can make even after the prosecution's witnesses testify that can allow you to defeat the case at the preliminary hearing. I hope you found this episode useful. In order to execute these 3 ways to beat a case at a preliminary hearing, I advise hiring counsel. They're going to know how to execute these actions because they've done it before and this is what they are trained to do. I hope you liked my video. Please subscribe, like, leave a comment, and share. Thank you very much.